Hi again, this is Wendy. Welcome back to my channel, Truly Sinister. This is part two of the Mickey Stines update and the Aaron Spencer update. So I have a couple more things to go over in regards to Mickey Stein's case. One of them is an ex-jailer or corrections officer spoke to the media or to the uh, to the media about her knowledge of the sex parties that the judge used to throw. So let's take a look at that. I just got off work. That's why I'm jumping right into the materials because I need to go to bed because I work again tonight. So I hope everyone is having a good Saturday morning or afternoon, wherever you may be. Okay. This is by Above the Law. They write some pretty good articles. Slain judge allegedly involved in nasty and sickening sex party ring. The details about what allegedly happened in the small town are shocking. This is written by Catherine Rubino. Okay, so this is the ex-sheriff, Mickey Stines. Why did Sheriff Mickey Stines shoot Judge Kevin D. Mullins? That's the question dominating Letcher County, Kentucky, since September of 2024, when the shocking incident occurred. Almost immediately, rumors began swirling, speculating exactly what was behind the crime. We know that Mullins and Stines had ate lunch together the day of Mullins' death, and several other people were in attendance at the business lunch. And one overheard Mullins ask Stines if they needed to meet privately in his chambers. Surveillance video shows Stines moments before the shooting using his phone to call someone, then using Mullins' phone. Both calls were made to Stein's daughter, and the daughter's phone number was saved on the judge's phone. That's why everybody automatically started speculating that the judge had something going on with the sheriff's daughter, and she has since made public statements declaring that to be false. So, according to Stein's attorney, Jeremy Bartley, misconduct allegations against former Deputy Benfields and Mullins are going to be crucial in Stein's defense. He has pleaded not guilty to murder of a public official. 3 days before Mullins' death, Stines gave a deposition in a civil case brought by Sabrina Adkins, alleging women under house arrest were extorted for sexual favors in exchange for more lenient treatment. According to the complaint in that case, it all happened in Mullins' chambers. Adkins' attorney said it's, quote, like they were running a brothel out of that courtroom. End quote. Now more people are coming forward with eye-popping stories of what happened behind the scenes in Letcher County. Sarah Davis, a former deputy jailer at Letcher County Jail, told News Nation's Bonfield the stories she heard about officials using their positions to have sex with inmates were, quote, nasty and sickening, end quote. Davis said she was aware of Mullins having sex with inmates. Quote, that's kind of the thing that everybody in the county knows, but it was confirmed to me after working in the jail. especially after being invited to a party myself, end quote. It was Mullins himself that Davis says invited her to a sex party, though she declined the invitation. I can't imagine what the balls it takes for him to openly invite her to. I mean, how does he know she's not going to report him or turn him in or whatever? I mean, it just goes to show you the balls this guy had and the fact that everybody in the county knew about it and he didn't care. What a pig. My ex-coworkers, they come out and even ask me now not to mention it. They've even them participating in the parties themselves. I'm not quite sure what that sentence is supposed to say. Apparently, they went to the parties themselves. I had another one ask me to go to another one of Mullins' get-togethers, and I declined. I declined again because it's one of those things. I was raised better than that. You know what I mean? If you know, you know. In the county, everybody knows. They might not speak on it. They might not want to be involved in it because there's so many people that have come out and spoke out about what Judge Mullins has done. Even if we're afraid to speak up on it, we need to, because this is that corrections officer speaking. They should have put this in quotes. It's kind of off-putting. It's kind of confusing. Let's start that again. They might not speak on it. They might not want to be involved in it because of fear of retaliation, because there's so many people that has come out and spoke out about what Judge Mullins has done. Even if we're afraid to speak up on it, we need to, because is this what we want for our next generation? Is that what we want for our kids? What we're going through, what our past people have gone through? Apparently, this has been going on for decades. Do we want that for them? And no, I don't want that for my daughter. I don't want that for my son. I want better for them. I want an actual community that's not based on if you got money and you know people, and if you're willing to get on your knees or on your back. It's sickening, and I want better for them. Taya Adams, which is that lady that we saw on the last podcast that Vinnie Politan was interviewing, that's Taya Adams, is also talking about her experience at these sex parties. As detailed by News Nation, Adams said Mullins, quote, started introducing me to his friends, the other lawyers, and we would do sex parties and perform shows and have sex with them for money, things like that, end quote. Asked if she felt she could say no to these encounters, Adams said no, and they would make sure to make you feel as small and degraded and belittled as possible to take your power away, Just 1 second. I will be right back. Just hold on. Okay, sorry about that. Adams continued, quote, "It was consensual, but it was the thing that we were so young, and then they used it against us and to destroy our." Sorry. Adams continued, quote, "It was consensual, but it was the thing that we were so young, and then they used it against us and to destroy our lives later," end quote. And keeping party about the sex and keeping party. I think she means in keeping quiet about the sex parties was expected. That was just a given, quote. She said, quote, "And who would believe it anyway? Because the whole town was doing it. Nobody cares. They're all swingers. It's all a big party to them. It was just so normal," end quote. This is crazy. It's like a movie. Okay. Davis believes the death of Mullins will lead to many revelations about the abuses of power in the town. He thought, when asked what she thought when he heard of the shooting, quote, "A lot of corruption was going to come out. I knew that this was going to be that. I knew this was going to be. That was going to be the beginning to set everything aside, to make people come in and people's voices finally be heard. Because even I believe that the sheriff, he either knew something or something was going on that he knew about that we all might not know about. But he was something to protect us," end quote. That's a little confusing, that last paragraph, but so what do you guys think about that? I still can't believe he came right out and invited that corrections officer, you know? I mean, what was he thinking? I mean, obviously he didn't care if she told anybody because he wasn't shy about talking to her about it. Okay, now I want to go back and have one more thing I want to go over, and that is his daughter's TikToks. Okay. Her name's Lila. She's a beautiful girl. That is her. In the TikTok videos, she has really, 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 really short hair, but it looks really, really good. So there's that. Okay. So Lila Stines, daughter of ex-sheriff Mickey Stines, addresses rumors in TikTok video. And yeah, I'm planning on playing the TikTok video. The daughter of former Letcher County Sheriff Sean Mickey Stines is taking to social media to dispel gossip surrounding her family. I told you I was tired. I worked last night. I can't talk. Lila Stines, 18, has posted 5 videos on TikTok since October 21st, addressing the fatal shooting of Letcher County District Judge Kevin Mullins inside his chambers of the Letcher County Courthouse in September of 2024. In a video shown during initial court proceedings, Mickey Stines is shown shooting toward Mullins several times following a conversation between the two men before leaving the room. Stines then surrendered himself without incident and later resigned as sheriff while still being held in custody. According to previous reporting by the Courier-Journal, Kentucky State Police Detective Clayton Stamper testified that a clip right before the shooting showed Mickey Stines using his own phone to call his daughter, who was still in high school at the time, then using Mullins' phone to call his daughter again. Following the testimony, rumors spread about the potential connection between Mullins and Lila Stines, which she said has had a deep impact on her daily life. Do you all not have anything better to do than sit and gossip? She said in her first TikTok video. You are taking my pain and making it your pleasure. In later testimony, Stamper said Mickey Stein's wife and daughter both told police she had not had, quote, any contact whatsoever, end quote, with the judge before the shooting. Stamper also said a review of Mullins' phone records found that call Mickey Stein's place just before the shooting was the only time the judge's phone was used to contact the girl, and there was no evidence of communication between the two. A trial date for Mickey Stines has not yet been set. Okay. So let's see if I can find one or a couple of the TikTok videos that she made. Okay. She looks like a Lila, I think. I don't know what that really means, but okay. She's beautiful. Anybody that can cut their hair that short after having it that long and still be pretty, that says a lot, I think. Okay. Okay, wait a minute. Why don't I have any sound? Oh. Hmm.
Only had about 950 followers. I did not
Start
take
over.
today to address a couple things about yesterday's video.
Turn it down a little bit. Let's see if we can find yesterday's video. She had one before this. Let's see. Let's see. Why would there only, maybe she took the first one down. She was a little. She was a little, like, little. Okay. So, that's not it. Still. It's still so loud. Okay. This is I think she might have taken the first one down. I'll look a little bit longer, but it looks like she might have taken the first one down. Okay, we'll see.
We're this hour, though, with brand new developments for you in the case.
First of all, let me apologize for who I have on my screen. But if this is the right video, then we'll have to ignore the fact that it's her. I apologize.
Of former Kentucky Sheriff Mickey Stines. He's accused of murdering Judge Kevin Mullins, and his daughter is now speaking out. This video here shows him shooting Kevin Mullins to death in the judge's office a year ago. At the time, there were rumors and some statements in the courtroom that led people to believe that this had something to do with Stines' underage daughter. Well, during grand jury testimony last month, a detective revealed that Mullins did not have any sort of relationship with Stines' daughter. And now, for the first time, we're hearing from 18-year-old Lila Stines, who talked about it on TikTok. We're playing the whole video for you unedited. Here we go.
Hello, everyone. My name is Lila Stines. I am 18 years old, and I am from Letcher County, Kentucky. Most of you may know me, and the others may recognize my last name. On September 19th, a little over a year ago, a lot of people I'm 18 years old, and I am from Letcher County, Kentucky.
Unedited. Here we go.
Hello, everyone. My name is Lila Stines. I am 18 years old, and I am from Letcher County, Kentucky. Most of you may know me, and the others may recognize my last name. On September 19th, a little over a year ago, a lot of people lives changed forever, including mine. I'm not going to go into detail. I will not be talking about it. But I just have one question. Do you all not have anything better to do than to sit and gossip? You are taking my pain and making it your pleasure. You're taking our stories and turning them into big entertainment pieces, jokes. When did that become okay? So my advice to the people doing that, get a job, do something meaningful with your life, and contribute to society. That's all. I come on here today to address a couple things. I only had about 950 followers. I did not think it would go anywhere. I thought, people from home's going to see it, maybe a couple others, and that'll be that. A lot of you were asking what stories, what do you mean by gossip? And what I mean by that is the stories that were made up about me and the other party. And that is where the gossip comes in at. I wasn't actually talking about the situation and what actually happened itself. I was more leaning towards the rumors that had been spread about me. I am aware of how serious this is and how much of a big deal it is. I was not talking about news or social media. I was simply talking about the people who sit at home behind a keyboard all day and say terrible things about my name. That's who I was talking about. At the end of the day, I'm just human. I'm just trying to learn how to process and cope with it all. I do want to add one more thing. A lot of you were saying, girl, this happened a year ago. Like, why are you still going on about it? To you, it happened a year ago. For me, when I wake up, it's the first thing I see on my phone. It's the last thing I see when I lay down, and I'm not looking for it. It's just right in my face. I have to deal with it every day when I wake up. So no, it's not gone. It's not died down. It won't for a while.
Now, Court TV has reached out to Lila Stines and
There's that. Obviously, the other party, the rumors about her and the other party she was speaking of is Judge Mullins. But she's an awesome girl. I mean, she seems very mature for her age. So let's all keep her in our prayers and hope for the best. So now I want to switch over to Aaron Spencer. A few things have come on to the docket this week that I wanted to cover. And let's get to it. Court. And they're not very long, so Okay. Let's start with um, let's start with we don't need to go over the order of extension on the deadlines. That's, for discovery and all that. Let's go to some. Well, let's start with the state's response to defendant's motion to dismiss felony information on the Fifth Amendment grounds, okay? So can I make this bigger? No, so let's do it this way then. Okay. State's response to defendant's motion to dismiss felony information on Fifth Amendment grounds. Comes the state of Arkansas by and through prosecuting attorney Chuck Graham and for its response to defendant's motion to dismiss felony information on Fifth Amendment grounds. Hereby states argument. Spencer's motion to dismiss has framed the state's filing of a criminal information, in this case, as a failure to comply with the Fifth Amendment. This is not so. 28 states currently file criminal charges by information. Footnote 1. These states are Arizona, Arkansas, California, Colorado, Connecticut. Well, just list the states. Let's not go through all those. When indictment is required, state prosecutions, grand jury law and practice, and that gives the case law. The current controlling state and federal precedent does not require states to use grand juries. Spencer's reliance on Ramos v. Louisiana is misplaced. Ramos concerned the requirement of a unanimous verdict in trials by juries under the under the Sixth Amendment, not the mode of charging under the Fifth Amendment. That decision did not override Hurtado v. California, which clearly held that the states do not have to indict by grand jury. While Spencer's motion presents scholarly argument that under modern incorporation jurisprudence, the grand jury clause should be recognized as fundamental, Those arguments remain outside the holdings of controlling precedent. This motion must fail as a matter of current constitutional law. While Spencer alleges that he is not requesting this court to overrule Hurtado, that is what would be required in order to grant Spencer's motion. It is well settled that states are not required to charge by indictment, but may charge by information. The Arkansas Supreme Court has addressed this issue many times and has consistently refused to extend the right to grand jury indictment to proceedings in the state. While much of the case law that has reiterated this well-settled matter is prior to the Ramos ruling, the Arkansas Supreme Court has stayed consistent even since Ramos was decided. The Ramos opinion was issued April 20th, 2020. The defendant in Waller v. State 2020 Arkansas 381, which was issued in November 2020, a pro se petition for writ of habeas corpus. ID. The defendant had been convicted of first-degree murder, arson, and first-degree battery. ID at 2. Among other arguments, the defendant alleged in his petition and in his argument on appeal that no grand jury indictments were issued for the charges of arson and battery. ID at 9. At that time, the Arkansas Supreme Court reiterated, citing both Barber v. Kelly and Hurtado v. California, post-Ramos, that the right to grand jury indictment proceedings does not extend to the state of Arkansas. Wherefore, the state of Arkansas respectfully requests that this honorable court deny the defendant Aaron Spencer's motion to dismiss. Respectfully yours. Submitted, Chuck Graham, prosecuting attorney. Okay, so let's go back to the ones that were just added this week. And that would be these two. The state's motion in limine to exclude evidence. Okay. In the Circuit Court of Lonoke County, Arkansas, 1st Division. State's motion in limine to exclude evidence. The state of Arkansas, by and through Deputy Prosecuting Attorney John Huggins, for its motion in limine to exclude evidence. 1. The defendant is charged with murder in the second degree in the killing of Michael Fossler. 2. Spencer's defense has given notice of 3 potential expert witnesses at trial. 3. Did I say 3? I meant 2. That was 2 if I said 3. Sorry. The curriculum vitae given to the state are attached as provided. See Exhibit A. 4. In reviewing, it appears the subject matter of expertise for the 3 would all be irrelevant to a murder charge or any potential justification defense. 5. The Arkansas Rules of Evidence address expert testimony in Rs. 702, 703, 704, 705, and 403. 6. The state is requesting a pretrial hearing for the court to determine any relevancy or admissibility of any proposed defense expert witnesses. Wherefore, the state moves to exclude witnesses identified as experts by the defense as irrelevant. Respectfully submitted, John Huggins. These are the expert witnesses that I guess the defense is planning on calling. And their background, so it's basically their resumes. These I can go over next time. This is 25 pages long, so we'll cover the witnesses in my next video. These are all blank. I wonder why they're blank. That's weird. So that was nice, short and sweet. And then we have the reply to state's response. Okay. Let's make it bigger. Whoops, sorry. That's really big. Okay. In the Circuit Court of Lonoke County, Arkansas, First Division, reply to state's response to defendant's motion in limine to exclude evidence. The defendant, Aaron Spencer, by and through his attorneys Aaron Casanelli and Michael Kaiser, states for his reply to state's response to defendant's motion in limine to exclude evidence. Spencer is charged with second-degree murder of Michael Foster, specifically that Spencer knowingly causing the death of Foster under circumstances manifesting extreme indifference to the value of human life. Spencer has asserted that defenses of justification pursuant to Art Code and annual, I guess, and it gives the case law. A person is justified in using deadly physical force upon another person if the person reasonably believes that the other person is 1, committing or about to commit a felony involving physical force or violence, 2, using or about to use unlawful deadly physical force, or 3, imminently endangering the person's life or imminently about to victimize the person from the continuation of a pattern of domestic abuse. Spencer has also asserted a defense pursuant to Arkansas Code. A, conduct that would otherwise constitute an offense is justifiable when 1, the conduct is necessary as an emergency measure to avoid an imminent public or private injury, and 2, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent public or private injury outweigh the injuries sought to be prevented by the law prescribing the conduct. Both statutes are justification defenses under Arkansas law. The state's charge requires proof beyond a reasonable doubt that Spencer knowingly caused Foster's death by deliberately creating a risk that was practically certain to result in Foster's death. See Turner v. State. The state must further prove that Spencer did not act under the reasonable belief that Fossler was committing or about to commit a felony involving force or violence against Spencer or Spencer's child, or that Fossler was using or about to use unlawful deadly physical force against Spencer or his child, and that Spencer's conduct was not necessary as an emergency measure to avoid an imminent public or private injury, and the desirability and urgency of avoiding it outweighed the injury sought to be prevented by the murder statute. Talk about a run-on sentence. How come it's okay in law to have run-on sentences? Both defenses are to be submitted to the jury if there is any evidence admitted supporting the defense, and if so, the court shall charge the jury that any reasonable doubt on the issue requires the defendant to be acquitted. Thus, the state must disprove these defenses beyond a reasonable doubt. Schnarr v. State, 2018, Arkansas. By statute, a justification such as self-defense is considered offense, and once raised, it must be disproved by the prosecution beyond a reasonable doubt. 1. The state's factual recitation is misleading and omits material facts. The chain of events that led to the death of Michael Fossler began in July of 2024 when he repeatedly sexually violated Spencer's daughter. Not as the state would have it, when Spencer first learned of the horrors Fossler had perpetrated against his child. The chain of events that resulted in Fossler's death definitely began with Fossler repeatedly sexually assaulting a then 13 and later 14-year-old child. The chain of events continued with Fossler being arrested and released for those crimes, yet continuing his manipulation and deception so he could continue assaulting the child. So he could continue assaulting the child until finally someone realized that he had taken her away from her home during the night. Footnote 1. It seems that the state is sensitive about the language used to describe the 67-year-old Fossler picking up his 14-year-old sexual abuse victim so he could take her to another location to commit more sex crimes against her. But surely no one can argue that he did not take her away from her home in his vehicle that night. And I believe he was going to kill her. I don't think she was going to come home. She was the only witness that was going to testify against him. So what do you think he was going to do? When Fossler realized that the Spencers realized that he had taken control of her that night, he fled with her, refusing to surrender her. The chain of events that led to Fossler's death began and ended with Fossler's criminal acts. The state's suggestion that the chain of events that resulted in Fossler's murder was Spencer's looking for information about Fossler from the mutual acquaintance is yet another attempt to distract from the chain of events that Michael Fossler started and perpetuated until his death. Just 1 second. It is yet another deeply concerning indication of its failure to blame the blameworthy. The dangerous pedophile instead of the man who found his daughter under the control of the pedophile. And while the pedophile was facing multiple life sentences and then some for his abuses of her. And while the pedophile was facing multiple life sentences. The state also repeatedly manipulates the statements and evidence in its response. For instance, the state says that Spencer told Higginbottom, quote, "Don't call anyone, don't call the police," end quote. Although that is not precisely what Higginbottom told police shortly after. When he came to speak with Miss Higginbottom, the person through whom Fossler accessed the child, Spencer actually said, quote, "Don't call anybody," end quote. She felt because a family member had been through a child sexual assault incident and the local police department in this jurisdiction had re-victimized her instead of helping her. She explained that Spencer had just learned of the assault from his daughter. Although she did not seem to believe it was true, and he wanted Fossler's contact information. I think that might be a he. I think that's supposed to say he, maybe. The state also omits the context as to the history of the family connection between the Spencers and Higginbottom and her role in the events that led to Fossler's abuse of the child. The state's response then purports to describe the events when officers arrived at Spencer's residence in regard to the rape allegation. In addition to the family's knowledge of local law enforcement's failure to assist in a prior child sexual assault investigation, Spencer knew that Fossler had a history in law enforcement and the military solely on Spencer's visceral reaction to learning details of his daughter's repeated rape by Fossler. The reality is that within about 7 minutes, the Spencers agreed that the child would speak to a female officer, and the conversation moved to exchanging information and proceeding with an investigation. Spencer and his wife then spent the next hour and 8 minutes or more talking with officers about the family history, the situation that led to their child interacting with Fossler, and information the child had reported to her mother while waiting on officers to respond, and filling other time with cordial discussion about everything from the military to animals to movies. Spencer and his wife invited officers to park in the driveway, invited them to sit on the porch, and offered them water. They completed forms and signed paperwork, answered questions, and cooperated with the officers' requests. After waiting nearly an hour, an investigator arrived and explained that another investigator would be assigned to the case, so she would not be speaking to the child that day. So they're just going to put it off. It's rare that kids, victims that young, will even speak up and tell anybody what happened to them, and they're going to put her off for a couple of days before they even talk to her. That's crazy. Backwards. Okay. Where did we leave off? They agreed to wait for a detective to contact them the following day to set up an interview with the minor. Spencer thanked the officers for coming, and they cordially departed. The state's attempt to reframe this interaction as one in which Spencer was mainly concerned about the identity of the mandatory reporter and his beliefs in the adequacy of the judicial system is not just false. Excuse me, just a second. Okay, sorry about that. Where did we leave off? The state's attempt to reframe this interaction as one in which Spencer was mainly concerned about the identity of the mandatory reporter and his beliefs in the adequacy of the judicial system is not just false, but completely tone deaf as to the situation the Spencer family suddenly faced and their fierce concern for their child. The state dismisses that Spencer did not refuse the officer's entry or refuse to cooperate or allow his child to cooperate. It certainly doesn't acknowledge the more than an hour that he and his wife providing officers with any information they could to help put Fossler in jail. While Spencer was worried for his child and angry at his daughter's rapist and the person he felt protected the rapist and who they believed lied to officers, he was quickly calmed and cooperative. Footnote 2. Spencer and his wife were both concerned that the person who contacted police had lied to them, as they knew she was not a mandatory reporter. They were not told that she had spoken to a third party who was a mandatory reporter or any of the other context of that conversation. They believed she had previously misled them about their child and had concealed the child's victimization at the hands of Fossler, her boyfriend. Oh, so Fossler was Higginbottom's boyfriend? Huh. They were upset because it seemed, with the information they had at the time, that she was again deflecting from Fossler's actions by accusing someone in the Spencer family of wrongdoing. It is difficult to imagine many fathers not feeling and behaving the same way when presented with such horrific, shocking circumstances. What Spencer said and believes still is that a parent has an absolute right to defend their child against someone who is presenting an imminent danger of harm, like manipulating a minor victim to have sex with him while awaiting trial for numerous sex crimes against her, when the judicial system cannot or will not protect them. Amen. And what matters is what actually happened, not what the state tries to piece together from picking and choosing words spoken months before the event that put the child directly within the control of her rapist. What really happened is that Spencer stood down. He did not attack Fossler when he confirmed his contact information. He went back home to talk to his family before they could do so. Oh, I'm sorry. He went back home to talk to his family. Before they could do so, while preparing their child for the process of reporting this that she was about to go through, officers showed up unexpectedly. The next day, they delivered their child for a forensic interview and allowed the criminal process to play out. They did interviews, delivered and consented to searches of electronics, provided witness information, etc. Fossler was arrested 4 days after that initial meeting at the Spencer's residence. He was seen by a judge the following day, and it seems an order out of the circuit court was entered imposing a mere $50,000 bond and generic no-contact order prohibiting Fossler's contact with any minor. It was not specific to the Spencer's child and did not include any restriction concerning their property or other places the child may be present. Despite the plentiful evidence confirming the use of social media platforms to commit the offenses, he was not restricted in his use of social media. He was not required to report to anyone associated with the court or law enforcement, and neither his internet usage or physical movement were monitored in any way. The state's response then begins to describe the early morning of October 8th, 2024, as if Spencer planned this night of his daughter being sexually assaulted by a 67-year-old man in order to efficiently and effectively, quote, take the law into his own hands, end quote. Such insinuation is offensive and absurd, and once again favors the pedophile instead of the victim. The state's own probable cause affidavit for the arrest of Aaron Spencer contradicts much its description of the morning Fossler died and certainly omits significant information about the events that led to Fossler's death. See affidavit for warrant of arrest attached as Exhibit 4. The affidavit states that Spencer told officers he had been woke up by his dog barking, which was uncommon, and went to check on his daughter. The sick event, I'm not sure what that means, events that had occurred earlier in the year. Aaron Spencer stated that the dog was in his daughter's bedroom, and when he opened the door, the dog continued to act out of character. Aaron Spencer further explained that when he looked closer at what he thought was his daughter in bed, he realized that it was actually a stuffed animal with his daughter's hoodie on it. Aaron Spencer you know how you when you're young, you would put a pillow or something under your blankets to make it look like you were in bed and you really weren't? That's what was done. Aaron Spencer stated that he became scared of what had happened to his daughter and had his wife call 911 to report her missing. Aaron Spencer then stated that he left his residence and began to search for Michael Fossler and his daughter. Aaron stated that when he arrived at the intersection of Highway 236 East and Highway 31 North, he observed the white Ford F-150 belonging to Michael Fossler turn off of Highway 31 North onto Highway 236 East, heading towards his residence, meaning Aaron Spencer's residence. Aaron Spencer then stated that he turned around, attempted to stop the vehicle by flashing his lights and blowing his vehicle's horn. Aaron Spencer stated that he was in fear for his daughter's life and continued to pursue Michael Fossler east on Highway 236 East. Aaron Spencer explained that when they of Highway 236 East and Highway 13 North, he hit Michael Fossler's vehicle in the rear, causing it to slide off the roadway. Aaron Spencer then stated that he exited his vehicle with a firearm in hand and ordered Michael Fossler out of his vehicle and to lay down in the ditch. Aaron Spencer stated that he had observed his daughter trying to exit the passenger side of the vehicle, but it appeared that Michael Fossler had grabbed her and stopped her from getting out. Aaron Spencer then stated that Michael Fossler exited his vehicle and had something in his hand, but did not know what it was. Aaron Spencer stated that Michael Fossler then lunged towards him, saying, quote, "Fuck you," end quote. Aaron Spencer stated that he then opened, what a cocky prick. I mean, he's out on bail for what, 43 felony counts of child SA, and he has the balls to get out of his truck and say fuck you to the child's dad after kidnapping her at 1 o'clock in the morning to do what? Commit more crimes against her and then possibly unalive her so that she can't testify against you since she's the only witness in the trial against you, and you're looking at life sentences. I mean, what a cocky prick. Wow. Aaron Spencer stated that he then opened fire on Michael Fossler, emptying his weapon before jumping on top of him and pistol whipping it. Aaron Spencer then stated that he got his daughter out of the vehicle and returned to his truck where he reloaded his weapon and called 911. Spencer certainly never told officers he thought Fossler had entered their home and forced the child into his truck, but when Heather and Aaron Spencer found their daughter's bed empty, they were worried, given what she had recently been through. They decided Heather would call 911 and he would begin searching for her in the area. They learned about that time from a family member that Fossler had recently contacted the child, and then they were understandably panicked. They were terrified that Fossler would not only SA their child, but that he would kill her or disappear with her, knowing that she was the critical witness to crimes that would put him in prison for the rest of his life. That's what I just said. That's crazy. And I haven't read this yet, so it's my first reading of it. It's a cold read. Like any normal father, Spencer left his wife to stay on the 911 call while he went out searching for her. Contrary to the state's suggestions, there's absolutely nothing about him doing this that is unlawful or wrong. In fact, it is exactly what most anyone would do. True. Contrary to the state's misrepresentation, in his interview after the shooting, Spencer did not say he was vigilant for, end quote, Foster that night. Instead, he explained that he learned what Fossler looked like, where he lived, and what vehicle he drove because he was aware that no one was monitoring Fossler. And while he did not watch Fossler, he needed to know if Fossler was nearby. He was worried that without any real barriers in place, Fossler would seek the child out and hurt her again, which he did. And so Spencer was right. He explained that he thought he had seen Fossler driving near the Spencer's home several times, but he was not certain it was Fossler. And if it was, Spencer would not confront him and instead would let the police do their job. But he remained aware of Fossler and aware that no one was watching him. So as he explained to investigators, Spencer stayed vigilant for Fossler if he came near their home. Spencer said nothing to investigators about immediately getting in his truck that night to look for Fossler because he was vigilant for him. He was, however, vigilant in his desire to find his daughter. While Spencer was looking for his daughter, he happened to pass Fossler's truck as it turned onto Highway 31, several miles from where the Spencer's residence is located on that roadway. His child in Fossler's truck. Spencer turned around to follow, and for miles, Spencer honked and flashed his lights. But Fossler sped up, fleeing with the child towards an intersection that would take them out of the area. Before that could happen, Spencer, having been trained in military tactics and maneuvers for disabling vehicles while avoiding significant injuries, pushed Fossler's truck into a driveway. Fossler exited the truck, coming towards Spencer aggressively with something in his hand, and Spencer shot him, unloading his clip. Fossler jumped into the ditch and continued to move and curse. And concerned that he may have a weapon, Spencer hit Fossler with the gun to abate any further threat. The state suggests that Spencer had other options that night, including that he could have called 911 when he found Fossler with his daughter. This kind of hindsight is inappropriate and irrelevant. First and most importantly, there is no law whatsoever in the state of Arkansas that requires any citizen to call 911 in the face of imminent danger. Arkansas law provides every citizen the right to protect themselves and their family from threat of harm. There is no condition to call 911 first and see if that works out. Second, Heather Spencer had already called 911, and Spencer knew that. Unless the sheriff's officers were ignoring the call, they were on their way. If it takes a second 911 call to make officers move faster when a child victim / witness is in a pending Y felony case is missing witness in a pending Y felony case is missing, that is a significant problem for the community. Third, the state's representations about Spencer's phone are simply wrong. Spencer explained to investigators that he could not get his phone unlocked while driving, and also that when he was going so fast, he didn't want to have a wreck making a call. Not that he was driving so fast he could not unlock his phone. The phone records confirm that this is true. He makes no call between the time he located Fossler and the shooting. He spoke with a family member before finding Fossler with his daughter. And while a family member sent him text messages during the interim time, the forensic examination does not establish that he saw those messages at the time she sent them. A critical review of the phone data proves that the times correspond to when a text is sent and received and do not reflect an action to use the phone to read the messages. Once he saved his daughter, his first and only call was to let his wife know she was safe. Although he did not reach her, his next call was to 911. Just 1 second. Sorry. I'll be right back. Okay, sorry about that. Okay. The state's assertion, Spencer, quote, had good reason to believe his daughter had snuck out of the house and had not actually been kidnapped that night, end quote, is outrageous. State's response at 3, it is as if it is as if the state is portraying this relationship between a child SA victim and her abuser as typical and consensual. Well, I wouldn't think that a 13-year-old can consent to sexual contact with a 67-year-old ever, no matter where you live. The idea that a parent in this situation would reasonably believe that their child was safe in this circumstance is preposterous. Okay. The idea that a parent in this situation would reasonably believe that their child was safe in this circumstance is preposterous. Whether or not she was forcibly removed from her home, Spencer and any parent in that circumstance had good reason to believe the child was in danger. This is especially true here where the rapist with control over the child is facing life in prison and the child is the sole witness. Even though it matters not how you label it, most reasonable parents would believe that this was kidnapping too. Footnote 3. The defense believes Fossler did legally kidnap the child and does not concede otherwise. However, it is irrelevant whether his conduct technically met the legal definition of kidnapping. The comments also demonstrate a replenishable. Oh, sorry. The comments also demonstrate a reprehensible blame the victim mentality. The state seems not to understand victimization of children by peas like Fossler. Okay, where was I? The child was 13 years old when Fossler began to groom and assault her, turning 14 years old shortly before he was arrested in July of 2024. Footnote 4. Grooming is behavior that manipulates and controls the child, as well as those around the child, to perpetrate the SA of the child. Among many other things, he told her often how much he loved her and manipulated her into believing him and believing that she loved him, even when he hurt her. Unfazed by the dozens of crimes he faced for his assaults against her and a no-contact order prohibiting him from contacting a minor, Fossler continued the pattern of grooming the child so that he could maintain his ability to control her and to sexually violate her until the very end. Neither the Spencers nor any reasonable parent would even consider the circumstances as just a teenager who snuck out of the house, quote unquote. The state seems to be arguing that it was unreasonable for Spencer to believe that Fossler presented a risk of harm to Spencer's 14-year-old daughter if he persuaded her to sneak out instead of forcing her out of the home. The state also seems to be arguing that Fossler did not commit any crime in persuading his 14-year-old victim to leave the house so that he could pick her up and, at a minimum, have intercourse with her. But Fossler committed multiple felonies against this child that night, yet the state seems to insinuate that Fossler did not, in fact, present a danger to his child victim on the night of October 8th, 2024, an insinuation that is so flabbergasting it is difficult to comprehend. The state does not, however, offer the last piece of its theory that since the state says Spencer really believed the child willingly joined her rapist that night, he should have called police a second time rather than follow Fossler and secure the child's safety. The state does not explain how Arkansas law requires any person to refrain from acting in favor of hoping for a police rescue in the face of such danger. The state likewise does not explain how its proposed plan of action would have assured the child's safety. The state does not explain how Arkansas law required Spencer to choose to let Fossler flee with his daughter instead of intervening to protect her. Nothing that Spencer said months prior has any hearing on these issues. The only facts that matter are those that put a child victim under the sole control of the pedophile who had repeatedly harmed her. Spencer's anger months prior in no way changes the scenario Fossler created that night. Whether Fossler forcibly kidnapped Spencer's 14-year-old daughter or groomed her so that he could continue to abuse her, if not disappear her, the analysis is the same. Either scenario created a legal duty and legal justification, and certainly reasonable cause for Spencer to act to protect his child from a sexual predator who refused to leave her alone and who presented a real threat to her safety, both as a victim and witness to his crimes. The suggestion that if Spencer thought his 14-year-old child may have gone, quote unquote, willingly with her rapist, Arkansas law requires him to sit back and hope for the best is outrageous. But this is apparently the core issue in this case. Thus, it matters not what Spencer felt or said months prior when he learned of Fossler's grooming and abuse of his child, because on the morning of October 8, 2024, Fossler, by his own choice, posed an imminent threat of harm to his victim, and Spencer had every right and indeed obligation to fight to save her. 2, this is not proper 404B evidence. The issue for trial is not whether Spencer killed Fossler or whether he intended to kill him, or planned to kill him, or knowingly killed him. Thus, the 404B analysis does not apply. The issue is whether at the time of Spencer's action, he had reasonable cause to believe that Fossler was committing or about to commit a felony involving physical force or violence, or was using or about to use unlawful deadly physical force, and or whether Spencer's conduct was necessary as an emergency measure to avoid imminent injury, where, according to ordinary standards of reasonableness, the desirability and urgency of avoiding the imminent injury to his daughter and or himself outweighed the injury to Fossler. Fuck, that was one long sentence. I don't understand why it's okay for lawyers to write run-on sentences, but in school we could never do that. That was crazy. These are complete defenses. The state has to prove otherwise beyond a reasonable doubt in order to convict Spencer. See Anderson v. State. 2003. Justification is considered an element of the offense and once raised must be disproved by the prosecution beyond a reasonable doubt. Spencer did not, as the state insinuates, stalk Fossler and kill him. Spencer did not allow Fossler to kidnap his daughter and rape her so that Spencer could kill him. Those suggestions are absurd. Fossler made the choice to violate the law and the court's order and to once again endanger his child victim. In fact, he was unrelenting in this regard. Fossler created and presented a real danger on the morning of October 8th, 2024, not Spencer, and therefore Spencer's initial reaction months prior has no relevance to Spencer's necessary use of force months later. Unless the state is planning to present a theory that Spencer set Fossler up to take his child and assault her on the morning of October 8th, 2024, so that he could kill Fossler, there is no legitimate 404B issue. The issue for trial is simply whether Spencer manifested extreme indifference to the value of human life, or whether he may have had reasonable cause to fear for her safety at the time he acted to protect his child. Whether Spencer also hated Fossler or was angry at him after finding out about Fossler's horrific crimes does not impact this analysis. If he had reasonable cause to believe that Fossler posed an imminent threat to his child, he is not guilty. Whether or not months prior Spencer had said things in anger about not wanting police assistance or thinking it is bullshit to suggest that a person could not protect another person from harm without going to prison, the issue for the jury is whether Fossler's actions created reasonable cause for Spencer to act in fear for his child's safety on October 8th, 2024, allowing the state to taint the jury with emotional reactions untethered temporally to the events of October 8th, 2024, violates Rule 404. Roman numeral 3. The state ignores Arc R. Evid 403. The state completely ignores Arc R. Evid 403 in its response. Even if relevant under Rule 404B, evidence may still be excluded under Arc R. Evid 403 if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury. C. Williams v. State, 2016. That is precisely the purpose and effect of the evidence at issue. Nothing about Spencer's comments in July 2024 shed light on his actions or Fossler's actions on October 8th, 2024. Even in July of 2024, Spencer did not act upon his frustration or anger. He tried to identify Fossler's residence and his vehicle, and he went home. He thereafter consented to searches and cooperated with investigators. He was, as any parent would be, diligent in trying to keep his daughter safe from Fossler, getting her therapy, limiting her contacts, homeschooling her, etc., and beginning to understand her suffering from the mental manipulation of this man. He was also, as any parent would be, diligent in learning information to identify the person who targeted and hurt his child, so that his family would be aware of this man. It would be aware if this man targeted her again. It was only when Fossler actually took his daughter from his home that Fossler presented an imminent danger to her that justified Spencer's actions to protect his daughter. As it turns out, unbeknownst to the Spencers, Fossler had been communicating with the child since about a month after his release on bond. With no bond condition or supervision dissuading him, he continued engaging with her and others on social media platforms and had directed the child as to keeping the communications secret. He had picked her up on 3 occasions between his release from custody and the night of October 7th, 2024, without anybody knowing. I didn't know that. She's lucky to be alive. On this final occasion, Fossler spent about 4 days or so persuading her to leave her house and go with him for the express purpose of committing criminal sex acts with her. She left the house around midnight, and Fossler picked her up near the Spencer home. Fossler then drove her to his home in Cabot, essayed her, and was driving her back near her home when Spencer encountered them. Spencer had no idea that Fossler had continued to communicate with his child after the arrest, and he certainly had no idea that he had continued to victimize her. Like any parent, Spencer went looking for his daughter when she was found to be missing. Once he saw Fossler with her in his custody, Fossler made clear he would not peacefully let her go. Like any parent in that moment, whether or not a 14-year-old child recognized the danger, her parents believed she was in danger in the custody of her rapist, and that Fossler had every reason to harm her to avoid life in prison. Fossler certainly did not, by his own behavior that night, indicate otherwise. Yeah, why was he trying to outrun Aaron Spencer? What, was he going to just go take her home? And I mean, what if Aaron Spencer wasn't driving around looking for him and he dropping her off? I mean, what, they weren't on a fucking date. He was assaulting her and abusing her. So was he just going to drop her off like they were on a date? What a dick. To permit the state to try this as a case of premeditation or intentional murder, as if there is no legitimate question as to the risk posed to the child victim that night, or as if Spencer somehow knew and planned to kill Fossler and allowed Fossler to harm his daughter again to do it, would be prejudicial error, allowing the state to try Spencer for his reaction to the initial disclosure of abuse and the gory details, and not on the circumstances and actions that led to Fossler's death. There's absolutely no evidence to suggest that Spencer knew Fossler would take control of the child and create a situation in which Spencer had to defend her. And to allow the state to suggest so is highly prejudicial and misleading. Spencer's comments in July are irrelevant to the issues in the case and threaten to confuse the issues for the jury's consideration and mislead them into a fundamental misunderstanding of the law and how the facts apply to it. Roman numeral 4, conclusion. Allowing the state to suggest that Spencer's actions to protect a child from her rapist were not motivated by concerns for her safety at all, but instead by the panic, anger, fear, or frustration he expressed 3 months earlier would be prejudicial error. His comments upon learning that his child had been essayed do not make it more or less likely that he reasonably believed she faced danger when Fossler had her in his control and refused to release her. Any suggestion that those comments demonstrate an intention or plan to act months later, when Fossler actually had control of the child for the purpose of engaging in criminal acts, is illogical, unsupported by the circumstances, and would mislead the jury. The events of October 8, 2024, Fossler's actions and Spencer's response to them are the relevant facts the jury must consider. The state should not be permitted to divert attention from those facts by implying that Spencer responded poorly or displayed bad character when he first learned of his daughter's victimization. Spencer did nothing to harm Fossler at that time, and instead he and his family cooperated with the authorities prosecuting Fossler. It was not until Fossler put Spencer's child in danger again that Spencer acted to protect her. There was nothing vigilante about Spencer's actions to protect his child on October 8, 2024. He acted in response to an obvious threat of harm. Although the state apparently disagrees with Spencer as to whether Arkansas law protects a person from prosecution for protecting himself or his family when confronted with imminent danger that is uncontrolled by law enforcement or the judicial system, that decision is for the jury. Wherefore, the defendant, Aaron Spencer, asks the court to grant the defendant's motion in limine and for any other relief the court finds appropriate. Respectfully submitted, Aaron Casanelli, Michael Kaiser of Lassiter and Casanelli, attorneys for Aaron Spencer. And then this is the affidavit for Aaron Spencer. Which is Exhibit A. Sworn before a judge. So, that is that for the latest motions in the Spencer case. So I want to thank you all for coming in this morning and joining me for part 2. I was really tired. I am really tired, so I'm going to get off of here and go to bed. Like I said, I have worked last night and I have to work again tonight. So I hope you all have a good rest of your weekend, and we will talk soon. Bye-bye.